Well, welcome back to the second day of Advanced Swaps. We're starting our first panel of the day, structured OTC derivative transactions, commercial use of swaps. Our faculty, David Lucking, Don McBean, and John Servideo. And I'm going to tell you a bit about them and then turn it over to the team to start the panel. First, David Lucking is the head of Allen & Overy's Global International Capital Markets Group, and he's based in New York. He has particular expertise in derivatives and structured finance transactions, as well as the regulatory framework that underpins the derivatives market. David advises financial institutions on a wide range of derivatives products and asset classes, including credits, rates, FX, longevity, in both funded and unfunded form. David is the U.S. advisor to the Credit Derivatives Determination Committee, which determines the credit events and other matters for the credit derivatives market as a whole. He regularly advises on various aspects of the transition of the over-the-counter OTC derivatives market to regulated trading platforms and central clearinghouses, as well as numerous other requirements of the Dodd-Frank Wall Street Reform and Consumer Protection Act, Dodd-Frank. He is a frequent speaker on the topic of OTC derivatives and derivative regulation. He's drafted a number of market standard document templates for ISDA and other derivative industry bodies, including the 2014 ISDA credit derivatives definitions and documentation for confirming trades referencing the iTraxx and CDX indices. Next, Don McBean. Don's at the end over here. We're out of order here today. Don is a partner in the Structured Finance and Securitization Group in the New York office of Catton. His practice focuses on structuring, negotiating, and documenting complex structured energy transactions, over-the-counter derivatives, and structured finance transactions. Don has extensive experience advising clients in the energy sector with respect to a wide variety of financial transactions, including supply contracts, offtake and hedging transactions, both physical and financial, tolling arrangements, and construction debt financings. He also advises international clients on accessing the U.S. capital markets through complex debt issuances backed by mortgages and other related assets. And also we have John Servideo, who's from Goodwin Procter, and he's a partner in Goodwin's capital markets and digital currency and blockchain technology practices. He advises clients on the origination, sales, and trading of financial instruments, including securities, rates, currencies, commodities, and digital assets. In the capital market space, Mr. Servideo assists dealers and issuers with structuring equity and equity-linked offerings, hedging and monetization transactions, securities repurchase agreements, programs, and corporate derivatives. In the blockchain space, he helps clients build and invest in Web3 protocols for staking, financing, lending, and trading virtual currencies. His previous industry experience includes serving as Assistant General Counsel at a global investment bank and as an attorney at another well-known investment banking firm. Before law school, he was an analyst in the real estate group at a large commercial bank. And so we have a very knowledgeable and experienced faculty. And so I'll turn it over to them, and I think Don is starting.
Great, thanks, Gary. Okay, I'm excited to be with you this morning to speak a little bit about loan-linked derivatives. So we're going to start with a question. With the recent increases in interest rates and commodity prices, are the institutions where you work using derivatives differently or more frequently than they were before? Oh, thank you. So we'll give a... Okay, well, holy smokes, we're almost exactly at half and half. So very interesting. Some of you are still voting, but we'll proceed with the presentation. But it looks like it's about half yes and half no. So to begin the discussion on loan-linked derivatives, we'll start with some context. And in theory, a borrower, if it were to incur secured debt, it could incur that secured debt and secure it and separately enter into swaps using different pools of collateral. In practice, that turns out to be inefficient for the borrower. So as a result, and in addition, borrowers rarely have the kind of liquidity required to fund two pools of collateral. So as a result, what typically happens is that there's one pool of collateral that secures both the loans and the swaps. Under this model, The borrower pledges the in-the-money value of the swap to the agent for the benefit of the secured parties, and the swap provider becomes a secured party under the loan and security documentation. When this particular approach is used, it's important to harmonize the loan documentation and the swap documentation to make sure that the expectations of the parties are met. Some of the key issues that warrant attention in this process include, for example, looking at rights that the swap providers might have independent of the lenders, looking at rights that the lenders may have independent of the swap providers, and also assessing the payment and lien priority afforded to the swap providers and to the lenders. So one question we might have is, if a borrower is incurring secured indebtedness, why does it need to enter into interest rate swaps to begin with? And the response is that lenders, in order to protect their investment, frequently require or mandate in the loan documentation that the borrowers hedge their interest rate risk through swaps or caps. This particular presentation isn't going to address caps. Those are a slightly different product. So most of what we speak about today doesn't apply to caps. Similarly, if the borrower has commodity price risk, if it's a project financing transaction or otherwise generates revenue through commodity prices, it wouldn't be uncommon for the lenders to require the borrower to hedge its commodity price risk as well. And if the borrower has a global footprint or otherwise earns revenues from a variety of different jurisdictions and a variety of different currencies, the lenders may also deem it appropriate to require the borrower to hedge its FX currency risk. So those are some of the reasons that a borrower might need to figure out how it can manage both securing a loan and securing a swap agreement. Now, in the context of an interest rate swap agreement, the lenders will frequently limit who may act as the swap provider. A common approach is to say that the swap provider needs to be a lender or an affiliate of a lender. This could give rise to issues under the anti-tying rules of the Bank Holding Company Act. So if you work at a bank and you come across a transaction that includes this model, this methodology of limiting who may act as a swap provider, it'll be important for you to check with your internal policies and procedures to make sure that you're not running afoul of the anti-tying rules. So we're going to speak for a few minutes now about interest rate swaps in particular. As a general matter, borrowers, of course, would prefer to borrow money at a fixed rate, whereas lenders prefer lending at a floating rate plus a spread. The solution that the lenders have come up with to accommodate the borrower's desire is that the lenders will lend at a floating rate plus a spread, but offer the borrowers the ability to hedge their interest rate risk through swaps. And frequently what the lenders will do is also require that a certain amount of the principal balance of the loan be hedged through interest rate swaps. And they may even go so far as to require a particular type of swap be used. So for example, I don't see it frequently anymore, but historically in the past, it wasn't uncommon for the lenders to require that a balance guaranteed swap or other similar type of swap that has a notional balance that changes over time to reflect the projected amortization schedule of the loan, that the lenders would require such an instrument. Okay, so then in the world of a transaction where the borrower is also required to hedge its commodity price risk, there are a couple of things to look at. Number one, the loan documentation frequently has very complex provisions that detail what types of transactions may be used to hedge commodity price risk. Some examples include in the power sector, if we're looking at a renewable project, perhaps a solar farm or a wind farm, a virtual PPA or financially settled purchase power agreement is common, or you could have a financially settled offtake arrangement or a fixed shape physically settled offtake arrangement documented under an ISDA. If the power plant's not renewable, say it uses natural gas, then a variety of different instruments could be used to hedge the key kind of pressure points that the borrower faces. And those are, of course, the price of its key input, which is natural gas, and the power price that it sells power for. So you can enter into gas contracts and enter into power hedges, or you can do products that take into account both the gas and power price, such as revenue puts or heat rate call options. And each of these different transaction types could have unique impacts on the ISDA documentation. And in that regard, one thing that needs to be considered if you're in the position of the swap provider or the borrower is whether or not your ISDA should be a quote-unquote single transaction ISDA, which might be appropriate if you're making a lot of adjustments to events of default or termination events in order to accommodate a particular trade, or if you can accommodate a particular trade through adjustments that would still enable you to enter into multiple transactions under the same ISDA. Lastly, I'll point out on this particular slide, lenders, in order to protect their investment or to increase the likelihood that they get paid back, if they view a particular swap agreement entered into by the borrower as crucial, they may mandate that the borrower obtain from the swap provider extended grace periods. And the way this would work is if there is a default by the borrower under that swap agreement, instead of being able to terminate immediately, the swap provider would agree to a certain period of time where both the lenders and the borrower could attempt to cure that default. And that period of time would be in addition to the customary ISDA grace period. Okay, there we go. So very quickly on some threshold regulatory issues, we'll spend very little time on this. I know the PLI has some excellent presentations on this topic. But of course, the borrower and the guarantors should be eligible contract participants. Just very basic, if the borrower is a financial entity, mandatory clearing may apply. If the borrower is not a non-financial end user, you may have mandatory margin rules. And so those are some of the kind of key regulatory issues that manifest themselves in these transactions. Okay, so now for just a few minutes, we're going to speak about some of the key issues that need to be identified and resolved under the loan documentation. So the first point here is what types of derivatives are actually permitted. And generally speaking, the best way to think about this is through the negative covenants. Most of the loan agreements will include a negative covenant that says something to the effect of the borrower will not enter into any swap agreements other than permitted swap agreements. And by looking at the definition of permitted swap agreement, you can assess what types of derivatives are permitted under the loan documentation. It may say something like a permitted swap agreement is a swap agreement entered into the ordinary course of business by the borrower with the following characteristics, and list the certain characteristics that the lenders have deemed are appropriate for hedging the borrower's risks. The loan documentation should also clearly distinguish or clearly define how a permitted swap agreement or what it means. So for example, sometimes the documentation is not very clear whether a permitted swap agreement constitutes a single transaction under an ISDA master agreement, or instead if the ISDA master agreement itself, together with every transaction, is collectively a permitted swap agreement. From the lender's perspective, you can imagine that they would like the tests or the limitations that apply to permitted swap agreements to be assessed each time the borrower enters into a trade, whereas the borrower and the swap provider would likely prefer a more broad or more flexible approach. Either way, I think the key here is that it should be clear, and certainly the loan documentation and the security documentation should give effect to and respect the key feature of the ISDA master agreement, and that, of course, is the closeout netting feature. Whether a permitted swap agreement is each separate transaction or all transactions under it is that collectively, what must be clear is that the closeout netting mechanics of the ISDA are given effect and are appropriately incorporated into the loan documentation and the security documents. Okay, so additional kind of issues that pertain to the loan documents are that sometimes, or frequently in fact, the derivatives or permitted swap agreements are kind of crammed into the definition of indebtedness in a loan agreement. Philosophically, that's probably not the right place for them to go, but that's where the market has kind of decided that they're going to go. So one exercise that needs to be performed when considering loan-linked derivatives is you need to look at the definition of indebtedness, determine whether or not swap agreements fall within that definition, and if so, of course, you need to go to the permitted indebtedness covenant to make sure that the borrower is in fact permitted to enter into swap agreements. Similarly, sometimes you'll find that the definition of or the swaps or derivatives also constitute investments under the loan document. So you'll need to look at your permitted investments covenant and make sure it's permitted there as well. And the lenders may also take the view that the portion of the lien available to the swaps needs to be capped so that the lender's claim isn't diluted. In that case, you'll find sometimes in the loan agreement as well as in the intercreditor agreement, there might be a lien cap that applies with respect to all swaps, or maybe not with respect to interest rate swaps, but it may well apply to other swaps, for example, commodity swaps. And there are a number of issues that arise with respect to lien caps. One is, how are lien caps assigned? Are they assigned on a per transaction basis? Or does the assigned lien cap apply to the ISDA Master Agreement and all transactions under the ISDA Master Agreement? Another concern to take into account is what happens, what does the documentation say? The consequences are if the borrower inadvertently over-allocates lien caps. So for example, if the aggregate lien cap is 50 million, but the borrower assigns lien caps to various different swap providers that in the aggregate add up to 60 million. How is that excess 10 million dealt with? This is something that should be clearly described and defined in the security documents and or the loan documents. You may also have in the loan documents certain types of swaps that don't fit within the parameters of what's a permitted swap, but are nonetheless grandfathered in or automatically permitted. And so there might be a bucket of permitted swaps that define specific swaps that do qualify as permitted. Okay, so now we're going to move on for a few minutes to issues that arise specifically under the swap documentation. Of course, the first issue to tackle is which version of the ISDA Master Agreement is going to be used. In the loan-linked derivative space, in most cases, the 2002 Master Agreement is used, but in some spaces, for example, in securitizations, and sometimes with hedge fund products, the 1092 ISDA is still common. One question to tackle that needs to be resolved between the lenders and the borrower on one hand and the swap provider on the other hand is whether or not certain covenants and reps and warranties from the loan agreement should be incorporated directly into the swap agreement. From the swap provider's perspective, it may well view the overall transaction as presenting a risk that requires additional rights, and that risk can be mitigated through incorporating particular covenants into the swap agreement. And these covenants, of course, would reflect or be consistent with corresponding covenants in the loan agreement. This would give the swap provider the ability to directly enforce a breach of those covenants and allow it to limit its exposure in the event that the borrower has run afoul of these covenants. From the borrower's perspective and the lender's perspective, you can imagine that this is not a desirable outcome, and borrowers and lenders would prefer instead that the swap provider rely on the cross-default provision and look through to the loan agreement, or rely on a custom additional termination event that is designed to kind of balance the equities here. So that's a point that needs to be resolved between the borrower and the lender and the swap providers. Another issue that needs to be taken into account is what are and what should be the consequences under the swap agreement in the event that certain key events happen with respect to the loan documents. So if there's a prepayment, a refinancing, a lender default, or perhaps even a material amendment, from the swap provider's perspective, non-material adjustments to the loan agreement probably don't give rise to anything problematic under the swap agreement. But if some event happens under the loan agreement that fundamentally changes the risk profile of the swap provider, of course the swap provider is going to want some kind of recourse. And the lenders and borrower, of course, want to balance this risk and have the flexibility to be able to make ordinary course and other changes in the loan documents without losing the benefit of the swap. So that's another issue that requires careful negotiation and a balancing of the equities. Another thing just to keep in mind, and we're not going to talk about this much, but I'll just flag it as a principle to consider, is that often the interest rate swap providers and other swap providers, so commodity swap providers, are treated differently under the documentation and may have different rights and remedies or different abilities to take actions. So you'll need to look at that as well and make sure that that works from your perspective. Just to kind of wrap up on key issues under swap documentation, you'll want to look at whether or not any specific additional termination events should apply. We briefly mentioned the cross-default provision. You'll want to think about whether cross-default or cross-acceleration is appropriate. What should be the consequence of a misrepresentation? And many loan agreements, there's a grace period. Under the ISDA, there isn't. These are things that need to be thought through in order to make sure that the loan documents and the swap documents are properly harmonized, while still giving the swap providers the types of protections that derivative counterparties expect to receive. Lastly, I would just say that on this particular topic, the ISDA Master Agreement has a broad kind of anti-assignment clause under Section 7, and frequently that needs to be modified, or the lenders and borrower would like to have that modified. So permitted transfers is another topic that comes up and frequently gets a lot of attention in this context. Okay, so now we're moving on to key issues that arise under the security documents. So of course, starting with basic principles, the definition of secured parties and secured obligations should be clearly defined. From the swap provider's perspective, there's no need to have a general definition that doesn't specifically mention the swap providers. Or in other words, swap providers have a strong preference for being specifically listed as a secured party and for having the obligations owed to them specifically listed as secured obligations. Swap providers, you also need to look at the voting rights they have. In some cases, swap providers only have voting rights after a default. In other cases, they have voting rights prior to a default. Where voting rights are granted prior to a default, they're frequently determined based on the net kind of closeout value of the swap. And sometimes the security documentation doesn't dictate how that value would be determined. So it might just say that the voting rights are based on the termination value of the swap, whereas it should go a little bit further and say, as determined as if the borrower were the defaulting party, something like that, to help you determine exactly which side of the bid-offer spread the closeout amount would be determined on. And then other issues that arise under the security documents are you want to make sure that the swap providers are appropriately incorporated into the waterfall. In particular, you want to make sure that not only termination of payments or the closeout amount is covered, there are also Section 11 indemnities that might apply. There are interest provisions in the ISDA Master Agreement. And of course, there are ordinary course payments under Section 2AI of the ISDA Master Agreement. So you'll want to make sure that the ordinary course waterfall, and most importantly, the closeout waterfall in the intercreditor agreement, if there is one, addresses all of the amounts payable under the ISDA, not just quote unquote the closeout amount. And I think just going here to the very last slide before I wrap up, in many cases, the swap provider will join a facility that has already been closed and been in place for a period of time. If that's the case, the swap provider won't be an original signatory to the intercreditor agreement, and the swap provider will need to accede to the or join to the intercreditor agreement through an accession agreement or a joinder. And the accession agreement or joinder will give the swap provider privity with the collateral agent. It'll enable the swap provider to appoint the collateral agent as its agent and grant the agent a power of attorney. And you should also make sure that the joinder is specified in the swap agreement and the deliverables so that the parties don't forget to deliver this at closing. So that concludes our discussion today on loan-linked derivatives. And I believe with that, I will turn the time over to John.
So I'll be talking about structured transactions on rates, currencies, and equities. And given that Don so thoughtfully discussed interest rate hedging and hedging transactions, I'll probably just move forward and talk about some examples of structured FX trading, and structured equity derivatives. So you see, these are the basic kinds of interest rate derivatives that Don talked about, including the documentation for interest rate derivatives that Don mostly covered. In addition to what he covered, also they're mostly done to hedge debt issuance, either a bond issuance or a loan agreement. And so with that, we'll focus mostly on FX and equities. So, and even, most of the basic FX trading is either cash trading or relatively simple, non-structured transactions like, forwards, or, which would be deliverable or non-deliverable, and then other kinds of forwards like participating forwards, window forwards, range forwards, depending on how you need your hedge to be structured, to meet your revenues or expenses, and what they may be depending on the fluctuation of your revenue expenses if you're, for example, a corporate borrower. So that's sort of your basic cash FX trading, and also your basic FX derivatives. So, and the difference between the deliverable and non-deliverable forwards is important, as we'll see in later presentations, is that non-deliverable forwards are swaps and subject to all the Dodd-Frank rules, and deliverable forwards and FX swaps are exempt from many of the Dodd-Frank rules. So that's a big regulatory difference to take note of. But let's take a deeper dive into like some common transactions. And again, the documentation for foreign currency derivatives is much the same as interest rate derivatives. The big difference is there's some legacy forms that are non-ISDA based that banks sometimes use, and banks will sometimes also use their own proprietary forms just for trading FX. But probably most of the time, a bank or anyone else will use it's just a regular 1992 or 2002 ISDA to document FX trading, because that of course makes it easier to enter into other trades in addition to FX, like rates in the future. And of course, there's all the Dodd-Frank protocols that you're still probably going to have to sign up to if you do something beyond just, even forwards. You'll have to sign up for Dodd-Frank protocols. So, in terms of like structured transactions, let's talk about deal contingent hedges. Deal contingent hedges are a hedge that puts on if and only if a certain deal closes. It's usually done most of the time in the context of M&A transaction. But deal contingent hedges can also be an interest rate swap that kicks in depending on the closing of a deal, and also like project finance, between like the offtake and the financial close. You could also do a deal contingent hedge, but I'd probably say 80% of them are M&A driven, where you'll have a financial sponsor or sometimes a corporate who wants to purchase a company or an enterprise, outside the U.S. in the local currency. So, for example, let's say an American hedge, private equity fund wants to buy a French company, and the price is €1 billion. The financial sponsor will need to hedge €1 billion and acquire €1 billion to close on the transaction. And the way it will do that generally, so it doesn't wear foreign currency risk during the closing period of the deal, which could be 6, 9, even 10 months, 12 months, a year, is a deal contingent FX hedge. So the deal contingent FX hedges can be a little bit complex, because in addition to having all the ISDA-based mechanics, as well as the FX mechanics, which are the relatively simple part, the deal contingent confirmations also contained all the points and definitions in the merger or acquisition agreement, whatever it may be called in the local jurisdiction. The plan and scheme of merger, and so there's a lot going on there, because you'll have to get maybe an M&A partner or an M&A expert in there to take a look at it. both in the U.S. For this principal sponsor and also in the local country to integrate the timing and all the merger and acquisition rules and contingencies that the local jurisdiction is going to incorporate. So there'll be some cross-border work between offices, and also just between the derivatives team and also the M&A team that covers the financial sponsor or the company to make sure all the working parts are integrated in the confirm, so that the deal contingencies are appropriately documented in the confirm. And this is important for both parties. So if you're representing the bank, it's important that the bank fully understands, so it can price up the risk of the confirmer, and that all the contingencies are well and clearly documented in the confirm. And same thing if you're representing the corporate or the financial sponsor, they don't get either stuck in a deal or that they don't want to be in or that dies. And so some of the key provisions that you negotiate into a deal contingent FX hedge, obviously it's just the timing. What are the dates? What are the near date, the expected date? What's the end date or the long stop date? There's a thing called the Phoenix provision, which basically says if the deal dies and comes back to life, then the FX hedge is back on, and then that'll be typically anywhere from 3 to 6 months after the original end date. There's a sort of moral hazard provision. It could be one-way or two-way that you have to negotiate and be thoughtful about. And of course, as discussed, all the conditions precedent to closing the deal need to be a condition in there for the FX hedge to pay out. The antitrust provisions, both in the U.S. and the local jurisdiction, regulatory diligence, tender offer, voter approvals, and of course board resolutions all need to be in there, and then also the timing and when the relative notices should be delivered. And it's important that if you're representing the bank gets all these notices so that the trader can